Teal.
I realised I was about to leave Whiteside too quickly. I hadn't really drawn out the point that, of course, Mr. Whiteside's tax liability had been adversely affected, which is why the claim had been brought. So his legal obligation had been adversely affected by the alleged misrecording in the deed. If you go to, well, you may still be on this page, 1831, you see in the middle of the page a paragraph where I'd read from the part beginning the ground, but the words before that beginning the only real matter. The only real matter of substance is that as a consequence of the mistake, the position of the plaintiff, Mr. Whiteside, as regards the taxing authorities has been affected and, as it turns out, adversely affected. So there's a clear sort of analogue one can see already. Nexus is saying our position as regards our employees has been adversely affected. What did the court make of that? Was that enough to grant rectification? It was not. And if one goes to the next page, the last paragraph, beginning, I proceed to the conclusion of Mr. Wolfe's formulation of the equitable right when he uses the words, to have the document reformed in such a manner that the document will place each in the same position as that which they intended. I think that must be qualified by saying in the same position vis-a-vis each other as they intended. And of course, as you know, that had already happened. And then the conclusion on the next page, last paragraph of that judgment, of Lord Evershead's judgment, if there be a hardship, it is not, in my judgment, sufficient to state that as things have turned out, the parties cannot now do that which will put the husband in the position he would have been as regards third parties. Had the document taken the other form, it's true that would have been the position, but in my judgment, that is not a sufficient ground for saying that in an action of this court, the court can, or at any rate ought, to rectify the instrument. So it is very much the case that, and this case has, as I say, been cited in many, many other cases, including the textbooks, and we're going to look at one of them, but it's very much that this case is authority for the proposition that there must be a dispute between the legal rights of the parties inter se.
And why is that? You say, what's the rationale for that decision?
I mean, I think I ought to concede that it is taken by this court in Whiteside as a well-established principle of law that they don't seek the origins of or don't explain the origins of, but I would have assumed that it is an aspect of the more general principle that the courts will not grant, will not entertain disputes between parties that do not have a dispute as to their legal rights inter se, not simply rectification, but just generally. And that is one feature of Nexus's case that we'll keep coming back to again and again. They want to hive off rectification in relation to what courts can adjudicate in respect to the terms of a contract of employment deriving from a collective agreement. They, or at least until this morning perhaps, there was some hint of it this morning, but they have not previously sought to challenge what I take to be entirely uncontroversial, which is that, to take, I think, a question of Lord Burroughs, who asked my learned friend, it may not have been, forgive me if I've got that wrong, could the union seek a declaration, which I think my learned friend misinterpreted to mean, could the union seek rectification? And answered, yes, they could, it was symmetrical. But I didn't understand whoever asked the question to be actually asking that question, but rather, could the union seek a declaration as to the legal rights of employees and employers? And the answer to that is always, well,
Well, but the question wasn't about the legal rights of the employees. The question was a declaration about the interpretation of the collective agreement that might affect the legal.
Yes.
And you say, yes, of course they can.
No, I say, of course they cannot. They never have done.
Why not?
Because it's not an instrument that the court will interpret for the parties. That is the...
But what if there's a dispute about the enforceability of the collective agreement? The court won't...
Well, when you say enforceability, you mean as between...
the union and the trade union, the union and employers.
But there can be no dispute. It's conclusively not enforceable.
Well, what if there's a term that looks like it might be agreeing that the collective agreement should be enforceable, but one side says, oh no, section 176 trumps it. 179, sorry.
Well,
Section 179 is only a presumption, so you can agree that it doesn't apply.
But there you say there would be a dispute as to whether there were legal rights or not between them.
yes, I mean, that's sort of the analogue of the Section 2 Law of Property Miscellaneous Provisions Act point. If the parties are coming to the court saying, we made an agreement that we believed established legally enforceable rights between us, then just as a court can decide whether a contract exists, it doesn't have to... It would be obviously circular if one had to prove there was an enforceable contract before asking the court whether there was a contract. So likewise...
If you had a collective agreement that was... the union said was ambiguous as to what the pay term was that had been incorporated into the employees' contracts of employment. Yeah. It's an unenforceable collective agreement as between employer and trade union, but it is automatically incorporated into contracts of employment. Do you say that all 1,000 employees must bring claims for declarations about the meaning of the term, or do you accept that the union could, in those circumstances, bring a Part A claim about in the court to determine what that term meant?
My lady, at the risk of sounding initially unhelpful, I say neither. These disputes, and I know my lady knows this very well, these disputes are not uncommon. They're always litigated as between employees and employer. They are never litigated, to my knowledge at least, by the entire workforce. They are litigated usually either, as in the case four members of this court heard only a few weeks ago, on a CPR 19 basis, where three, in that case, employees on behalf of a much larger number as formally representing that larger number, having the question determined. That, I would say, applies in my experience in 5% of cases, 10% of cases at most. The other 95%, a group of employees, and I mean, this happens literally many times every day.
What's to stop the union bringing the claim?
Well, my lady, that's the question that's begged, as it were, by this argument between the parties today. The union has no legal standing in respect of that agreement.
Your point is that I can't sue you because it would help me to achieve some benefit with a third party, essentially. I mean, that's what you say this case shows. It might, if I win against you, that might be advantageous to me because it will enable me to claim against somebody else. But as between you and me, if there's no legal dispute or no legal rights turning on it, the court won't entertain it.
Yes, I mean, to be fair, this case specifically addresses the question of rectification, whereas my lady was asking the more general question, which is, can the union act as a party in order to determine the meaning or effect?
Well, the principle is going to be the same, isn't it?
Well, I say so, yes. My learned friend, I'm not so sure.
Well, I think he takes the mirror image position to yours. He says that there could be a claim for a declaration as to what the collective agreement means.
Yeah.
Well, if he does say that, then I would say that is even more obviously heterodox in that it is... there have been centuries of litigation in terms of what collectively agreed terms apply and in other words, do they apply or not? Are they apt for incorporation? Are they not apt for incorporation? And as to the meaning of collectively agreed terms that have become terms of employment, and if I'm wrong, I apologise, I have never heard it suggested before today that such an action could, certainly has ever been brought as between the collected parties. And I can explain why I think that is obviously correct, but certainly it is unprecedented.
There's no list between them, as it were.
Yes, there's no need for it. That's the point. I mean,
well, no need is another matter. That doesn't show you can't do it.
No, but I was.
You have to say you can't do it, and I'm taking you to argue that you can't bring a claim just because it will achieve a collateral benefit for you. It has to resolve some legal issue as between you and the other party to the litigation.
My Lord, yes, as a general principle. So that's the first of our two principles. The second, we say it's peculiarly important in relation to industrial collective agreements. I obviously yet to come to that. But then I was addressing the implicit point my lady was taking against me potentially, I thought, which was the alternative is that the whole workforce has to sue or be sued, which would be a point of some practical policy significance if that were the case, but it isn't.
No.
So
we have to consider not merely the remedy of rectification, because we're now being asked to consider whether any remedy can be sought by a union against an employer in respect to the collective bargain.
Yeah, I mean, just because
including a declaration.
Just because I was involved in it, and therefore it springs to my mind. But the textbooks and the case law is littered with these, and my learned friend's probably been involved in several himself. There was a case, I think from 2010, which went to the Court of Appeal, called Malone and British Airways, which was about whether or not cabin crew flying on British Airways aeroplanes had certain rights to minimum numbers, basically, per plane, as set out in a collective agreement. That was the subject of a determination by the High Court and then the Court of Appeal, which ultimately was in favour of British Airways, that the term of the collective agreement, and they went into what they thought the rationale for it was. There was evidence from union witnesses and employer witnesses, was not apt for incorporation, and therefore the employees who brought the claim failed in their lists against their employer in seeking to rely on that term. As I say, it's just the one that springs to mind. Those sorts of cases, is it a term of my contract of employment as an employee, are not infrequent. As to the, Lord Burroughs, I think, asked my learned friend, and I thought he assented to the proposition that interpretation and rectification are closely connected. I would agree with that. There are cases every day in the employment tribunals and in the civil courts where employees and employers are disputing the proper interpretation of terms that have been incorporated from collective agreements. I have never heard it suggested that those claims could or should be brought by unions. And if my learned friend is saying that, and if he accepts it's, as my Lord Legate suggests maybe he would have to, if he accepts it's a necessary consequence of his argument that that be so, then that really is a huge, not an incremental change in the way employment litigation is conducted. The last case I was going to take you to, just on the issue of rectification, I'll do it shortly, is the Ashmore case.
Just before we leave it, sorry.
No, of course.
I'm just sort of thinking that are your propositions coming close to us having to look at the thorny, long-standing question when the courts might or might not be wishing to answer hypothetical questions? Because I think what you're saying is it's tied into legal rights as between the parties.
I think, I mean, the short answer is I haven't given it any thought until you just asked the question, and it's quite a big question. But my initial reaction is, insofar as there's any force in considering that issue, it's that they are two manifestations of a more general proposition that a court will not adjudicate other.
It might be an actual, not hypothetical issue, but not between these two parties.
Yes. So I think, as it were, you could have an issue between two parties that hasn't yet happened, and that's incidentally one of the lines of reasoning in the Whiteside. In other words, if Mr. Whiteside had brought his claim for rectification 1 year earlier, it would have been fine. But now it was academic as between, or hypothetical as between him and his wife, because of the supplementary deed. But they're both manifestations of the more general principle that there must be a list between the parties to the action, I would suggest. But I haven't looked at the hypothetical point.
But separating out, as I'm suggesting we should, the question of who the parties are and what the issue itself is, it could be the case, could it not, that in a dispute between the employer and the employees, you could, first of all, have an argument about what the term of the collective agreement means, and then there might be an alternative argument that if it doesn't say what it was intended to mean, it should be treated as having been rectified.
My Lord anticipates not quite word for word, but a submission I was about to make in, say, 20 minutes' time. But that was, to be fair, on the premise that my learned friend's case was less wide than I think some of the court are interpreting it to be. But it would be, I would say, ridiculous if, where such claims are so often argued in the alternative, as indeed the Court of Appeal pointed out, that an employer should have to argue one aspect of its defence in one jurisdiction at one time, and then another aspect of its defence in another jurisdiction against another party at another time, which is what my learned friend would say if you take his arguments on ground 1 and 3 together. The Mango Hair case, although at least that was done properly case managed, the issue was raised right at the outset. They went off to the High Court, they came back. But there's no need for any of that. So I was going to take the court to 1654. This is in the judgment of Justice Ralph Gibson. No, I was right first time. Well, Justice Peter Gibson. And he's reviewed all the authorities, including Whiteside, and then I'm going to take this as short as I can. Just below A, you see the words Mr. Justice Weinrott. He was the first instance judge in the Ray Cullen Ashmore case. And so at D, when he says the judge summarised the effect, he's now referring to Mr. Justice Weinrott in that case. The judge summarised the effect of the authorities in this way. In my judgment, the principle established by these cases is that the court will make an order for the rectification of a document if it is satisfied that it does not give effect to the true arrangement between the parties or to the true intention of a grantor or covenantor. Notice that's I suggest, an exclusive list of the type of instruments rectification is concerned with. More importantly, for present purposes, the following words: and if satisfied that there is an issue capable of being contested between the parties or between a covenantor or a grantor and the person he intended to benefit. Next sentence. On the other hand, the court will not order rectification of a document as between, I would say even as between, the parties, etc., if their rights will be unaffected. And then Lord Justice Peter Gibson says, for my part, I accept that summary as correct. So we do say, with respect to my learned friend, that there are clear, well-established principles set out in a number of cases, including those two Court of Appeal authorities, which he is implicitly ignoring.
Are there any cases outside this context, but in other contexts, where the rights between the parties to the litigation have depended on the incorporation of terms from another contract, and it's been argued that those terms, or one of those terms, didn't correctly record what was intended to say?
You mean outside of the employment?
Yes, outside. I mean, there are all sorts of contexts, aren't there? I mean, areas I'm familiar with when you incorporate charter party terms into a bill of lading, but there's lots of examples. And I'm just thinking that maybe some point along the way somebody's argued that incorporated term doesn't reflect, as in the document, doesn't reflect what it was meant to say, and then the question would have arisen whether you can treat it as meaning what it was intended to say, even though that one of the parties, at least, maybe both, to the original contract aren't before the court.
We looked and couldn't find. Right. But I mean, to take us, the only point I can take against myself is I have a memory, now that my Lord mentions charter parties, that one of the textbooks that my learned friend cites, I think it's now, but it may not be, does refer to the sort of instruments which are susceptible to rectification and lists things like bills of lading, bills of exchange, I think maybe charter parties. But I don't think in the context of, well, I would hope not, otherwise I would have failed to draw an important case to the attention of the court, and my learned friend, I suspect, would have done so if it existed anyway. But I don't think so in the context of a dispute that wasn't a dispute between the parties to the action. We certainly couldn't find one.
Could I just mention one feature of both Whiteside and Ashmore, which is brought out by the closing summary by the judge endorsed by Lord Justice Peter Gibson, that the court will not order rectification of the document as between the parties if their rights will be unaffected and if the only effect of the order will be to secure a fiscal benefit. Because that was a feature of Whiteside, as well as I understand it. Now, to my mind, that has sort of echoes, if you like, of Pitt and Holt, where it used to be said, well, trustees, if they've misunderstood the tax effects of a particular transaction, should be allowed to undo what they have done in order to, in essence, create a new tax situation and save the trust tax or so on. And after a lot of litigation, the result was arrived at that, no, they couldn't do that. They, in effect, were stuck with the transaction as it had been put to the tax authorities. Now here, the doctrine that seems to be exemplified by Whiteside and Ashmore is that if you've made a mistake, as in Pitt and Holt, the trustees have made a mistake, you've put a particular transaction before the tax authorities and they've taxed you on that transaction, and there is no underlying reason between you and the other party to that transaction to change it, you're stuck with the transaction that, admittedly by mistake, you put before the tax authorities. I just wonder whether it might not be said that that's a particular aspect of, if you like, I don't know whether it would be a discretionary limit on the application of rectification or something more fundamental, that you can't change your tax affairs retrospectively for your own benefit by saying, well, I didn't mean to enter into the transaction as it appeared I did, and as I put it before the tax authorities.
I think well, first let me concede that I don't know the particular case that my Lord has referred to, so I certainly should say nothing about that. But in terms of whether Whiteside and Ashmore are, as it were, examples of a much more specific principle than the one I was contending for, I say no. I say so primarily because of the passages I read from Whiteside, which make it quite clear that the court was deciding that it was in the absence of a dispute between the parties that was a critical factor. And then they went on to say, even though the benefit to Mr. Whiteside of us rectifying the instrument in terms of his tax affairs was a real one, I accept that the syntax of the sentence that my Lord just read from the bottom of the quote from Mr. Justice Weinlot's judgment is a little different, because it says, and if the only effect of the order will be to secure a fiscal benefit. But I take in context of it being a summary of the previous authorities, not all of which were tax authorities, that in fact, and there means something in context, something similar to despite the, or and if the only means something similar to despite the effect of the order being only to secure a fiscal benefit. I don't think they're conjunctive. And of course, in Chitty, our sort of starting point, the statement of that proposition is certainly not limited to tax cases or anything, any more narrow category. So just coming back to our case for a moment, it is precisely and only because Nexus and its employees are in dispute about how much it should pay them that the question of rectification arises at all. And just as in the situation where employees and their employer are in dispute as to whether a particular provision of a collective agreement got incorporated, that issue, that rectification issue, must, we say, be determined by the parties who are in dispute. And coming back to a point that Lord Leggett raised, I do say that it is important to distinguish between, on the one hand, a term, that is to say, a legally binding obligation of the contract of employment from a provision of a collective agreement, which is not legally binding. It becomes a term of the contract of employment, and it is in that capacity and that capacity only that it can be interpreted. The courts can decide whether it belongs there at all. It can be rectified. So we do that.
There are two different questions, though, aren't there, which may not both have the same answer. One is whether you can rectify a document which doesn't itself create legal rights and obligations. The other is whether you can grant such rectification or decide the point in a case where there is no issue of law in dispute between the two parties to the litigation.
I agree there are two different, although I would say related, questions. I say related because it's the character of the instrument that you're seeking to rectify which will, to some extent, govern whether rectification is available. So, I mean, to take the extreme example of Lord Burroughs and my learned friend going out for dinner, that's the sort, even if they were to have stated it in a document, that's the sort of document which, for obvious reasons, isn't susceptible to rectification.
No, but this is an odd situation because you have something which doesn't, a form of agreement that doesn't create legal rights and obligations between the parties to it, but it does create legal rights and obligations between one of the parties to it and somebody else.
Yeah, as did for Mr. Whiteside. I accept there's a spectrum, as it were, but the dividing point of principle, we say, is in relation to the type, the category of document, is as to whether it creates legal rights at all between the parties to it, or if there is only one party to it who's granting or covenanting between that party and the grantee or covenantee. But to the wider point my Lord makes about the two different questions, it may not matter at the end of the day, I suppose, whether if the action had proceeded as originally conceived, namely in an action against the employees for rectification, whether the court had said at the end, as I say it ought to have done, we rectify the term of employment as between the defendant and claimant, or whether it had said we rectify the underlying collective agreement for, or the relevant part of it, from which the term between the claimant and defendants derives. As I said before lunch, I entirely accept that in practice you get the same result either way. If you are rectifying the term of employment, you are rectifying the term of employment that would apply equally to all relevant employees. So you are, in effect, rectifying the collective agreement. And of course, in a sense, it's a distinction without a difference because the words you are rectifying, as my lady pointed out, generally won't actually get written down into a contract of employment. So it's like the letter, the Persimmon case, where it became incorporated into the contract between the sellers of the land and the buyers of the land, that a unilateral document needed to be rectified. So in this case, you could imagine, as it were, that every individual employee has a contract of employment, and stapled to it are all the current provisions of the Red Book. I realise that's a metaphor because one doesn't constantly staple and unstaple every time. But that's the legal reality. And all you're doing in a rectification claim as between the parties to the contracts is saying wherever it says in all of those incorporated documents to Fred Bloggs's and everybody else's contracts, basic pay consists of X, you're now writing basic pay consists of Y, or overtime is to be calculated by reference to A, not B. So
but the question still is, who's made a mistake in recording their agreement?
Well, that's a question.
And it seems to me that here the people who've made the mistake are the union and the employer, and not the employer and the employee.
That's right, and that's a question of evidence, just as in the Malone case I spoke to you about, where the question was what was act for incorporation and what the parties' intentions were when they agreed this term. The evidence was not the evidence of, or not principally at least, the evidence of any cabin crew member. It was the evidence of the union negotiators with the evidence of British Airways. But I, yes, entirely accept that the evidence is in relation to that matter. So I do say that of itself is sufficient to dispose of ground one, but we do say, and I keep saying I will make this good, I now try to, that there is a peculiar difficulty in the way of my learned friend's submission by reference to the character of collective agreements. And we say he rather downplays or selects from the comments in the two cases he referred to in that regard. There are three obviously related reasons. I'll just go through them. The first is that I do say it is well recognised that rectification only applies to certain classes of documents. The court has seen the repeated references in both Whiteside and Ashmore to contracts, deeds, covenantors, grantors. Those are the classes of documents. Documents which establish legal rights as between the parties to them or as between the only party who makes it and someone to whom he or she is undertaking a legal obligation. Those are the only classes of instrument that are susceptible to rectification. And Nexus and the textbooks it cites do not provide any...
What about the contracts that are exchanged that aren't legal documents?
Because they are purporting to be. First of all, it's a statutory exception.
Well, it is. Yes, I can't remember if it's always been a statutory exception, is it, or was it start off?
I don't know that.
Before it was put in the statute.
I don't know. But it is an exception that to some extent proves the rule. But more importantly, it's the same quality of investigation as whether there is a binding contract. The court is deciding whether two parties who obviously intended to be bound by a written instrument are in fact bound, or rather because of section 2(1, there is a lack of formality that means they are not. And if the only question is in order to achieve the proper formality as rectification, then the statute says that should happen.
But this argument seems to me to prove too much, because if you're right on this, it means that the collective agreement can't be rectified, and so if it is the mistake in drawing it up, employees are just stuck with what they've got.
Well, no, my lord, that's where I with a very heavy heart say I continue not to accept the starting point of my lord's analysis, because it is precisely because what we are rectifying is not a term of a collective agreement, it's a term of a contract, that it can be rectified, and therefore there is no problem at all.
But the term of the contract just says the Red Book will be incorporated, or the letter of agreement will be incorporated.
Well, my lady,
so what do you rectify?
I say no.
Well, show us the term that says salary is calculated or overtime is calculated by reference to both
241
salaries.
is the letter agreement, but I'm sure the court...
Well, no, not the letter of agreement. That's the term in the collective agreement.
Which becomes incorporated just as the
Where,
persimmon...
well, show us the term.
Show us, it'd at least be helpful to see the term of incorporation, the incorporating terminology.
Well, I think my learned friend, have you sent it to the court?
We haven't sent it to the court. It isn't in the bundle, but we have the standard contract that includes the corporation document, which we can provide to the court.
Thank you.
And we can do it by email. So.
Thank you.
But it is what I know my lady will recognise as a standard incorporation clause. So it's
Well, that's why I'm asking, because the standard incorporation clause just says your terms as to pay are set out in the Red Book or are incorporated.
Exactly.
Yeah.
And therefore...
So my question remains, how does it help to rectify that provision unless you rectify the Red Book?
But we're not, but my lady, we are not rectifying the incorporation clause. The incorporation clause, it has nothing to do with the rectification claim at all. The incorporation clause is the staple. The incorporation clause is the same... is a direct analogy of the part of the sale agreement in Persimmon Homes, which said, I can't remember the detail of it now, but whatever is in that schedule will determine the properties that we're selling or not selling, or something of that sort.
But they had to amend, they had to reform the disclosure letter. They couldn't just reform that term. They had to reform the disclosure letter.
They did, my lady, but they reformed it as part of
A suite
the
of
contract between the parties. And just as you reform the letter agreement term, I'm trying deliberately now to use a neutral description, so that what appears in your bundle at 241. So just as you are reforming those words, that's neutral enough. You are doing so because, and you can only do so because they have become, via the incorporation clause, a term of the contract of employment. And as a term of the contract of employment, everybody agrees they're a term of the contract of employment. They're just saying it's the wrongly recorded term. Everybody agrees, therefore, that the reform is to the term of the contract of employment.
But if the Red Book hasn't changed, then there'll be a discrepancy between them, and the whole point is they're meant to be the same as the Red Book.
But well, my lord, I fear I'm repeating myself, but if you succeed as an employer in reforming the term of the contract, and if that term only exists as stapled via incorporation from another document, whether it's collective agreement or not, then, of course, that reforms the words as they appear for any material purpose, whether it's in the Red Book, in the contract of employment, or anywhere else. So the effect...
So you're doing exactly the same thing.
Yeah, just calling it something else.
You're using the evidence that is only realistically, as you've said, between the union representatives and the employer, but you say, but you can't do it in one procedure, but you can do exactly the same in the other procedure. That is, if you've got the union and the employer together, you're out. If you've got the employees and the employer together, you're in. But it's exactly the same exercise.
Yes, and let me build on that, if I may.
And you say that that's because formally there is a rule of law that says you have to have a legal dispute or affecting the legal rights of the parties, even though the practical effect of all this, if you didn't believe that there was such a rule, would produce exactly the same result and would actually, in many senses, presumably, enhance the ease and efficiency of the system.
Well, my lord, can I take the practical issues now? Because I think it's been far too long assumed that the balance of convenience, as it were, lies with the appellant, and it doesn't. Let's just take two examples that all the court, I'm sure, will be familiar with. One is collective agreements, as we've seen, in fact, from one of the cases, do not last forever. They are terminable at will. They are often terminated, and it is a very well-established principle of law that the terms of the contracts deriving from those collective agreements, which are, as it were, shredded, persist, and either party can sue on them. So you have, in this case, if Nexus, in a fitted industrial peak, had terminated immediately, just as the NCB did to the agreement it had with the NUM, the Red Book no longer exists. It's now, from now on, there may be no further incorporation. They may de-recognise the union. But the terms continue until varied lawfully. Now, it would be odd, I put it at its lowest, if in those circumstances a rectification action had to be between the parties to the now non-existent collective agreement rather than the parties to the ongoing employment contracts. But that's not by any means the most frequent or the worst offending situation. Much more frequently, employees whose terms of employment have been incorporated from a collective agreement between employer A and union X find themselves, by operation of law usually, pursuant to regulations you're probably all familiar with, called the Transfer of Undertakings Regulations, employed at a later date on the same terms by employer B, who may recognise Union X or Union Y, or often no union at all. I hope this is all familiar, but I can sort of put more flesh on the bones if it isn't. Now, if Nexus were correct, in those cases, if a dispute arises between the current employer and its employees, and it could easily do so, as to whether the terms have been correctly recorded in the suite of documents that the new employer has, being the contract of employment compendiously, and the employer wants to seek rectification, what is my learned friend saying should happen there? That the employer should sue the employer A and Union X, with whom neither of whom it has any relationship with, and possibly never had any relationship with? Or is it, and I suggest the answer is obvious to this rhetorical question, more sensible for the employer to rectify the term of the contract of employment between it and its employees, with whom it has an ongoing relationship, because that's, after all, what the whole issue is about, the terms of employment as between them, and in doing so procure evidence insofar as is necessary and or available from the ex-employer and or the union. So there's the category of document that tells against being able to rectify a collective agreement as between the collective parties. There's the obvious practical impossibility of doing so in quite common cases. And then there is this issue of policy that I said I would turn to about the justiciability. And can I just quickly go to a couple of passages from those two cases that my learned friend has already helpfully taken you to. The first is the Ford Motor Company case at 1194. Between D and E, in the judgment of Mr. Justice Geoffrey Lane. Coming to the present day, almost to the present day, one finds that the report of the Royal Commission on Trade Unions and Employers Associations, under the chairmanship of Lord Donovan, deals with this matter at considerable length. I wish to make it clear at this stage, one does not, of course, read these publications, even publications from as august a source as this, as being precedents in any way affecting the legal decision of this case. But they are, as I say, matters which, in my view, are material when one is considering the root problem, namely the intention of the parties. I turn now to the report. It reads as follows, paragraph 470. In this country, collective agreements are not legally binding contracts. This is not because the law says they are not contracts, or that the parties to them may not give them the force of contracts. And then 1195 at B, that it does not happen is not, as we've already said, due to the law. It is due to the intention of the parties themselves. They do not intend to make a legally binding contract, and without both parties intending to be legally bound, there can be no contract. 471, this lack of intention to make legally binding collective agreements, and these are the words from this case that I would particularly commend to the Court's attention, or better perhaps, this intention and policy that collective bargaining and collective agreements should remain outside the law is one of the characteristic features of our system of industrial relations, which distinguishes it from other comparable systems. It is deeply rooted in its structure. And as my learned friend helpfully explained, since 1974, that position has been formalised by statute, and one case after that statute examined the statutory language. Can I take you to 1542 within the Monterosso Shipping Company case, where Lord Denning, Master of the Rolls, said this, beginning at A: "It seems to me that the true distinction is between the existence of a contract, which is substantive law, and the remedies for breach of it, which is procedural law. The right course is to analyse the statute and see whether it negatives the existence of a contract or not. If there is no contract, there's nothing to enforce. That is substantive law. If there is a contract but the statute says it cannot be enforced except in writing within a stated period, that is procedural law." In this present case, as I construe Section 18, that's the predecessor to Section 179, it negatives the existence of any contract at all. The section draws a distinction between an agreement and a legally enforceable contract. The agreement is not intended to be binding except insofar as the parties say it is to be binding. If, and insofar as they say it is to be binding, then there's a legally enforceable contract. Then at 1545, the judgment of Lord Justice May, at C, sorry, my computer is frozen for some reason. Never mind. First, I think that the precise wording of Section 18 is noticeably different from the statutory provisions in the Statute of Frauds or Limitation Act. In the latter cases, the relevant statutes use the phrase either "no action shall be brought" or "an action shall not be brought after the expiration of," which are very different from "shall be conclusively presumed not to have been intended by the parties to be a legally enforceable contract," and have a much more mere procedural flavour about them than in the Act of 1974. The subject matter of Section 18 is collective agreements as defined by the Act, and these are certainly agreements in the sense they contain and are intended to contain mutual understandings. This being so, when it is then provided that these mutual understandings are conclusively to be presumed not to have been intended by the parties to be a legally enforceable contract, I think the correct construction of this phrase is that in a collective agreement, unless the parties specifically state to the contrary, they are to be deemed not to have intended to create legal relations between them. If this is the proper approach, then the latter is not merely procedural, but must have substantive effect. The corresponding provisions in the Statute of Frauds and Limitation Acts contemplate agreements between the parties intended to create legal relations, but prevent those legal relations being enforced by the courts, either because of the absence of a formality, such as writing, or the passage of time. This, I think, is a totally different situation from that in which the parties never contemplated that the agreement to which they have come between themselves would create any legal relations at all. In these circumstances, I think a collective agreement to which the provisions of Section 18 have not been applied is no contract at all in the sight of the law, but merely an arrangement between the parties, the enforcement of which is to be achieved, if at all, by other means. That is not unusual in English industrial relations. And then finally, to the leading case of NCB NUM at 1580, apologies. At H, having considered the Ford Motor Company case and subsequent statutory interventions, Mr. Justice Scott observed, these statutory provisions, like Section 34 of the 71 Act, concentrate on the intention of the parties. If the collective agreement is to be legally...
Sorry, I'm sorry, you're reading...
it's right at the bottom of the page, the last two lines on page 1580. If the collective agreement is to be legally enforceable, it must contain a provision which states the parties so intend. If it does not contain such a provision, there is an end of any question about its legal enforceability as between the parties. Note in passing, before we get to the critical passage, at 1582, between E and F, nothing I have yet said deals with the question whether all or some part of the 1946 scheme, that's the collective agreement, may not have achieved, by incorporation into individual mine workers' contracts of employment, legal enforceability as between the board and the mine workers in question. And the scope of the conclusion that the collective agreement was not legally enforceable had to be examined in the context of the union's submission at 1584 at E, and I think my learned friend read from a bit between F and G, but can I pick it up at E? Mr. Den submitted that the de facto consequences of collective agreements entitled them to some recognition by the courts. He submitted that although not legally enforceable, the courts ought to be prepared to entertain and decide questions as to the construction, effect, and terminability of collective agreements. And pausing there, that I take to be the substance of the wider, more principled position that the court was putting to me either was Nexus's case or at least should be if it was to make coherent sense. The answer was, I am unable to accept these submissions. And then just below F, a passage to which my learned friend referred, but I think didn't read out, if they intended to be legally enforceable and so state it will be, and the courts will have jurisdiction to decide questions arising under it, but if they do not intend it to be legally enforceable, then no rights of which the law or courts can take cognizance will be created under it. The parties cannot have it both ways. They cannot, on the one hand, keep their collective agreement outside the area of legal recognition, and it might be said legal interference by the courts, and on the other hand, ask the courts to decide questions that arise under it. And I took it, until this case, to be well established, and my learned friend has put nothing in front of the court that casts doubt, let alone contradicts this principle, that collective agreements are not simply not enforceable as contracts, but are, by long industrial practice and policy, outside the area of legal recognition or legal interference by the courts, equally as regards questions of construction, effect, rectification, terminability, as enforceability as terms.
But the presumption in section 179 is just as to legal enforceability.
Well, I won't repeat what Lord Denham...
I know you say that means that has a wider implication, but that the words are.
Well, as I say, I don't entirely accept that because I do respectfully endorse the analysis in, sorry, I've already forgotten, Monterosso, is it? The Monterosso Shipping Company case of Justices Denning and May. I do think that looked at the statutory language of 179 as a whole, it is not a procedural provision.
Now, one of the elements of a contract is there has been intention to create legal relations, and if you don't have that, you don't have a contract.
That is what I would, yeah.
But this goes, does it not, further than you yourself would accept, because you accept that the courts, at least in between, as between the employer and the employee, does have to construe a collective bargain.
Well, my Lord, I fear I'm going to repeat myself, but it is, and I'll keep returning to this metaphor because I do commend its utility. It is construing or interpreting a term of a contract that has been incorporated or stapled to a short document that says your terms are...
You say they're interpreting the contract of employment.
Yes, they are.
And one of the terms of that happens to have the same language as the term in the... Not doesn't happen, but it does, it by design has the same language as the term of the collective agreement. Yes. But what they're actually interpreting is the term of the contract of employment.
Yeah, I wish I could be ingenious enough to think on my feet of a different source. Hypothetically, a contract could say, we are incorporating, and I can't, as I say, think on my feet sufficiently ingeniously, but we are incorporating the terms of some document or instrument that isn't a bilateral instrument and that isn't a collective agreement. Now, it would be very odd indeed to suggest that there should be an action between, I mean, it could even be a historic document. It could be a document created by someone who died 100 years ago. I mean, it would be very odd to suggest that what one was in law construing or interpreting was that original document, albeit that the effect of a court's decision at the term of the employment contract had to be rectified was that, I mean, the court would presumably find that the original document, whether it's a collective agreement or some other document, mistakenly recorded what it should have said, and as a result, the term of Mr. Siegel's contract of employment should read X, not Y. And of course, in any future case, and this gives the lie to one of the more, we say, far-fetched problems hypothesised by my learned friend, of course, in any future case, if the same contractual term derived from the same document, then the courts would refer to the earlier decision and say, well, look, of course the result's going to be the same. So it has just the same practical utility as a decision as between the collective parties if one were permitted, which we say it isn't. And there's no reason not to... sorry, can I just check? Yes, Junior, showing greater ingenuity than myself, says that sometimes you do get rates of pay that are not incorporated from a collective agreement, but set by a professional body. Now, if...
I'm glad to see the yellow stickers are still on.
I was going to say, we eschew all electronic communication on this side of the court, yes. So, drawing the threads together on issue one, I try anyway. In a circumstances where a dispute has arisen between Nexus and its employees, that's why we're all here, because of the Anderson litigation, as to the correctness of a written term of their contract of employment, albeit stapled to a short document within the current terms of the Red Book, Nexus seeks to have that dispute determined not in an action between the parties to the contract, but between the parties to the collective agreement from which it derives. And we say that that is despite the following reasons that undermine such an attempt. First, the only reason it's justiciable at all is because it has become a term of the contract of employment. Secondly, we say it, well, I was going to say it is uncontroversial, we say it should be uncontroversial, that any dispute in relation to that term could only be determined in an action between the contracting parties, whether that be to determine if it had legal effect, what its meaning is, and whether it's been breached. Only until perhaps this morning would it have, was Nexus's case, as I understood it at least, in respect of potential rectification, does Nexus suggest an action might instead be brought by the parties to the collective agreement? Third, the long line of cases establishing that rectification cannot be granted unless there is a document which confers legal obligations and rights on the parties, and there is a dispute between the parties to the action by which it is sought. Fourth, the practical problems of having to bring rectification claims against a union who made a collective agreement will often be insurmountable, not just inconvenient, but insurmountable, particularly where the employer concerned was not a party to that agreement. And fifth, the well-established principle that for reasons of industrial policy, collective agreements are outside the area of legal recognition and legal interference by the courts, including as regards questions of construction or effect. So, although it may seem odd for me to say so after such a spirited exchange between bar and bench both this morning and this afternoon, we do say it's not properly arguable, this ground of appeal, as a matter of legal principle and authority. And therefore we do ask, not rhetorically, why is it being argued? And if one goes to 144, sorry, when I said 144, I meant 244, apologies. one sees that following the 4-year Anderson litigation, Nexus's solicitors wrote a letter before action headed Tyne and Weir Passenger against Stephen Anderson and others, and at paragraph 2 said this: "We consider that the appropriate defendants to any claim issued by our client for rectification would be all employees of our client to whom the collective agreement applies." The response to that letter isn't in the bundle, but we quoted it, and the quote is at 144 within our written case, where solicitors for the employees wrote, "You are stopped from raising arguments now that were open to your client to raise in the substantive proceedings. You are seeking to pursue arguments about mistake, effectively trying to relitigate the decided claim on a different basis," etc., etc. So it was purely in order to avoid the risk of the court finding an estoppel or an abuse of process if it brought its rectification claim as originally planned against its employees that many months later Nexus decided to proceed against the unions. At the same time, I note, as my learned friend was pleading mistake in defence to the subsequent employment tribunal claims in Bolam and the other cases. So even at that stage, they wanted a foot, as it were, in both courts, if that's the right metaphor, which I suspect it is not. And so we end up with the argument, for the first time since 1974 at least, that the provision of a collective agreement should be justiciable between the parties who made it, moreover susceptible to rectification, despite there being no dispute between those parties, arising only in the unique circumstance where an employer finds itself potentially stopped from raising rectification against some of the proper defendants, the employees who are parties to the contracts of employment, because it has fought and lost a claim brought by those employees without raising the supposed need to rectify the material terms of those contracts. And I recall when I first looked at this case, I wasn't involved until this stage, I did doubt whether there was going to be any precedent value to a decision on this particular point, because the facts are so unique and extreme. And we say that that is no basis for what even Nexus describes as a potentially incremental change in the law, let alone for what we argue would be a wholesale departure from long-established legal principles and practice. Can I then turn, I'll try and be brief, to the supposed practical difficulties identified by Nexus if we're right. They say, well, if you're right, all sorts of problems would arise. I leave aside the point of principle that practical considerations can't determine whether or not a dispute is justiciable, a point made very forcefully by Mr. Justice Scott in the NCB case in one of the passages I've read out. Can I just also give you a citation for time? There's also a discussion by him at 1583 at C, where the next 2 or 3 paragraphs make the same point in a different context, where he is being urged by counsel for the NCB because of the practical significance in terms of public perception to make declarations, and absolutely refuses to do so, describing that as not being part of the court's legitimate function. However, leaving points of principle to one side and assuming this court is interested in weighing the material practical advantages or disadvantages of bringing rectification claims against, on the one hand, employees, or on the other, the union, we say that the advantages are very much in favour of the former. I've already referred to the most important, that at the time the action is brought, whereas the parties to the material contract will always be in an ongoing relationship, and moreover in dispute with each other, one or both of the parties to the collective agreement may not be in a relationship with the corresponding contractual party, indeed may no longer exist. So, to cases. Nexus asserts that there would be forensic disadvantages in requiring individual employees to be sued because the unions might not wish to give evidence or provide disclosure. Well, first, as we pointed out, there are well-established and well-used jurisdictions of courts and employment tribunals to ensure that they have evidence and documents from third parties. And anyway, if, in practice, if an employer is seeking to resign from the terms of a collective agreement to the detriment of members of the union which made it, and if that union is still around at all, in relationship with the relevant employees, then it will inevitably be keen to provide the relevant evidence and disclosure. But there's a more fundamental point. If the union had no interest in establishing the relevant entitlements of its members, there would be no more incentive for it to give evidence to contest a rectification claim brought against it than in respect of a claim brought against its members or its ex-members. So the procedural matters raised by Nexus are even more divorced from reality, we say, at paragraph 22 of its case. And this comes back to a point I know that I've expressed in answer to questions from Lady Simmer and Lord Leggett. Collective agreements, start that again. Collective disputes in the sense of disputes between all or a section of a workforce and their employer are regularly litigated in tribunals and courts between employers and employees. And employers and trade unions and their lawyers are well used to managing litigation of that sort. And as I said, four of this court heard such a dispute a few weeks ago, and in fact, in another few weeks' time, I'll have the privilege of appearing again in relation to another case of that type, where in 5 different actions, 5 different High Court actions, a few employees who were members of one union in different government departments successfully sued their employers to establish that all employees of that department had the right to have their union subscriptions paid by check-off, including employees not in that union. That's not the point that's coming before this court, but it's the same litigation. So even in this court, you've got 2 within a couple of months, and they happen all the time. So the suggestion that an employer might have to sue its entire workforce, or the entire workforce might need to sue the employer, just simply pays no regard for industrial litigation reality. And we note that Nexus has not provided a single example of such a case. Even if it were, in theory, necessary to obtain a remedy on behalf of or against every employee, that's what CPR Part 19 is designed to assist with, as happened in the Tesco case. And there was no difficulty of the sort imagined by my learned friend in deploying Part 19 in such a case. But more fundamentally, that's just not the way these disputes are ever resolved. Rather, a single employee, more normally a few employees, brings a claim. The determination of that claim resolves the legal position in respect of all employees. And there are dozens of such reported cases. We've cited a few. Take the present dispute. Assuming no issue of rectification, following the conclusion of the Anderson litigation, employees' entitlements under their contracts, by reference to the letter agreement, would be known, and it is absurd to imply that Nexus would have required other employees to bring similar claims in order to establish the same entitlements. And if it did, and it never does, but if it did, the tribunal has similar powers to the civil courts to strike out a claim or defence that has no reasonable prospect of success. Now, the same principle would apply in theory in reverse. That's to say the employer is bringing a claim against a few of its employees, though we know of no case where that's happened. If an employer obtains a declaration against a few employees as to the proper interpretation of a contractual term affecting its entire workforce, for example, including, in an appropriate case, a declaration that the wording of that term needs to be rectified, it is perhaps even more fanciful to imply that when that employer pays its workers according to the contractual term as interpreted by the court or rectified by the court, other employees might seek to claim by reference to a different interpretation of the term, or the terms as unrectified. And just such a fanciful suggestion is mooted in my learned friend's skeleton at paragraph 43, where Nexus imagines that if an employment tribunal rejected employees' claims because the term needed to be rectified, that might be problematic because other employees might nonetheless bring the same claims in other tribunals, and they say it is at least conceivable that a different tribunal would reach a different conclusion. Well, Conceivable, literally speaking, yes, but could it ever happen in practice? No. We say that Justice Underhill was right to assume the exact opposite at 203 at the end of his paragraph 65, that the finding by a tribunal in respect of one set of employees would in practice have made it impossible for those employees to present similar claims in respect of future alleged underpayments, and by the same token impossible for other employees to do likewise. In other words, decisions, not that there have been many or any, but decisions as to the rectification of the terms of an employment contract are just as binding in practice, probably more so actually, on other employees as decisions as to the existence of a term or the meaning or effect of a term. But, and this is the last sentence or two I say on ground one, the trees must not obscure one's view of the wood entirely, and even if there were practical difficulties that might arise in an exceptional, to date unprecedented case, they are certainly not such as to require this court to depart from those principles that the parties to a legal instrument are only able to seek rectification of that instrument as against each other, as to their respective legal rights, and the long-established principle that the courts do not have jurisdiction to adjudicate in any respect the terms of collective agreements, or at least what they should be, what their meaning and effect is, as between employers and unions. Round three, I hope deal with fairly shortly. This is the ground in respect of which it is important to distinguish, as I think at least two members of this court suggested to my learned friend, two different things. What are the disputes an employment tribunal is empowered to adjudicate and the remedies it's empowered to award? Secondly, what are the issues a tribunal is entitled to consider in adjudicating those disputes and awarding those remedies?
Sorry, the second.
What are the issues that a tribunal is entitled or has jurisdiction to consider in adjudicating those disputes and awarding those remedies? It's only in the formal regard that employment tribunals are a creature of statute. Statute sets out the jurisdiction to determine certain types of dispute and the jurisdiction to award certain types of remedies. And we give an example of a very well-known scenario which applies in unfair dismissal cases, but also in underpayment of wages cases, which is the contract illegal, or has it been in a material sense illegally performed? There's no statute that says a tribunal is entitled to make such a determination. They've been doing so regularly for decades, and it's not suggested by my learned friend that they shouldn't. We've cited a couple of cases. I just do want to take the court, though, to one case which offers, we say, a much closer analogy to the present case. That's at 1065. It's the case of Bryler. That was a claim for underpayment of wages on the basis that a term allowing the employer to recoup its recruitment costs from the claimant's final wages in certain circumstances was an unenforceable penalty clause. So the claimant had the deduction made from her wages. She said, you can't do that because the clause you're relying on is an unenforceable penalty. Now, there's no statutory provision entitling an employment tribunal to determine whether any term of an employment contract constitutes an unenforceable penalty clause, and yet the tribunal and the EAT held that the tribunal has the jurisdiction to make that determination in order to adjudicate the claim for unpaid wages. And moreover, another closer point of analogy, in determining whether the term relied on was unenforceable as a penalty or valid as a genuine pre-estimate, the tribunal was required to ascertain the predominant purpose of the provision at the time the contract was entered into. Much as in a rectification claim, the court has to ascertain the intention of the parties at the time the contract was made. Now, in that case, which is why I say it's useful, the very same point that my learned friend makes here was raised by counsel for the employer at 1070. The EAT, His Honour Judge Hand, King's Counsel, said this at paragraph 19. Mr. Scott, counsel for the employer. Mr. Scott's first point was that the Employment Tribunal should not concern itself with anything more than whether the contractual agreement fitted the parameters of section 13. His argument is that the Employment Tribunal is not concerned with whether the sum might be unenforceable. That's a matter that's the province of the civil courts, the county court and the high court. All the employment judge is concerned with is the statutory rubric of section 13, and once it is established, the agreement for the deduction falls within either subparagraph A or B, that's all section 13, then that's the end of the matter. I don't agree. It seems to me that the deduction contemplated by the contract must be a lawful deduction. If it's a penalty clause, it's not a lawful deduction. I cannot accept the argument that it's not within the province of the tribunal to decide this matter. That's no different to a number of other aspects of a contract of employment that fall to be considered, construed and adjudicated upon in the context of the statutory jurisdiction. As I say, we say the analogy with this case is, it's not exact, but it is compelling. And of course, my learned friend made a similar argument in the Anderson proceedings. Can I just, because I apprehend that it'll be repetitive otherwise, can I just give the references? Within the Court of Appeal's judgment at 857, Lord Justice Underhill cites from Lord Justice Nichols' judgment in Delaney and Staples, which focuses on the words properly payable, or as my Lord Legate summarised it, properly due, and the fact that it's a deeming provision. Anything that is properly payable must be paid. Any deficiency will be treated as a deduction, and concluded that a dispute on whatever ground as to the amount properly payable cannot have the effect of taking the case outside of the predecessor section, section 8.3 as it was then. And then at page 859, at paragraph 18 in Lord Justice Underhill's judgment, he draws on that in the context of the argument there that it wasn't for an employment tribunal to construe a contract, and says at subparagraph 2, if there's a question of any character as to whether the sum in question is properly payable, that question must be resolved by the employment tribunal. There is a further point that he makes, which is that, and I'm now at page 863, paragraph 27, subparagraph 3, there is no good or even frankly comprehensible policy reason for carving out from the jurisdiction of an employment tribunal one particular kind of dispute necessary to resolve a deduction of wages claim. On the contrary, to do so would be incoherent and would lead to highly unsatisfactory procedural demarcation disputes. Employment tribunals are well capable of construing the terms of employment contracts governing remuneration, etc. We say that that is no less applicable to the present issue, and we accept that the Court of Appeal approached it, the three members of the Court of Appeal, in different ways. Lord Justice Underhill didn't, I concede, adopt that somewhat, I would say, straightforward or simplistic approach, but rather relied on those cases about the Judicature Act, Mostyn and Breslau, though does say that the purposive construction of the statute, as he put it, would tend in the same direction as the decision in Agarwal. Lord Justice Mayles does adopt the broad approach of principle that we say is appropriate. The references are paragraphs 132 to 135 at page...
Sorry, you're going to have to...
132 to 135 at page 218. Summarises Delaney and Staples, Agarwal, and then says, as to the policy issue, at paragraph 135, although the particular issue is different in Agarwal, the reasoning is equally applicable for the question whether an employment tribunal can order rectification if it's necessary to decide whether to do so to determine a deduction claim, and in my view is equally convincing. Moreover, if an issue arises whether what has been agreed in an employment context, negotiation about wages, is correctly recorded in the party's written contract, that is an issue which an employment tribunal with its specialist expertise is particularly well able to decide. And we say that in respect of this ground, Nexus rather ignores the substance and rationale of that analysis, focusing only on the narrow issue of whether the tribunal has statutory jurisdiction to make an order of rectification, which we accept it does not, any more than in Bryler.
I thought you said it could have made a rectification order. I thought you were supporting the judgment of Lord Justices Nails and Newey rather than Underhill on that.
Nails.
Nails, yes.
Lord Justice Newey preferred to leave the matter.
He didn't decide it.
Yes.
Are you now abandoning that?
No, I'm not at all. I was hoping, because of the time, to get away without having to do a rather exact analysis of Lord Justice Mayall's judgment, but I will do so now that the point's being raised.
Well, I'm not necessarily asking you to. You haven't got very long, but you are saying the tribunal has statutory jurisdiction to grant the remedy of rectification.
I don't. I do not say that, and I say, nor did Lord Justice Mayall's, though I accept he twice uses the phrase power to order rectification, but he does so in context as a shorthand for determining issue of rectification. That is the whole thrust of paragraphs 132 to 135. And I note that my lady expresses...
well, it's just that Lord Justice Underhill disagreed with that. So I wonder why he needed to. Well, it was just about resolving the dispute.
But my lady actually puts her finger on one of the reasons why I say I'm entitled to make the submission I've just made, because Lord Justice Underhill and Lord Justice Mayall's read each other's judgments in draft, and Lord Justice Underhill refers to these paragraphs of Lord Justice Mayall's judgment, and if one goes to 201...
He says there isn't really such a difference between us after all, or something like that, doesn't he?
Yeah, I do not disagree with anything he says in paragraph 132, which is the paragraph which says has the power to order.
Sorry, page 201, which paragraph?
It's the very top of the page, so the end of 59. I am not sure how substantial the difference between us really is. I do not disagree with anything he says in paragraph 132. I agree with his proposition that a deduction may be lawful by reference to a contract which needs to be rectified, and he makes the same point at the end of paragraph 60, referring to Nexus's pleaded case that pleaded defence, in the later tribunal claims, where he notes that Nexus is pleading that the agreement is susceptible to rectification. In other words, you can't order it, but it's still susceptible to rectification, is consistent with both my approach and that of Lord Justice Mayall's. Now, I'm always glad to enlist the support of such a powerful ally, but I would actually submit that if one reads paragraphs 132 to 135 as a whole, it is obvious that's what Lord Justice Mayall's was saying, not that they have the statutory jurisdiction to make an order of...
Anyway, it's what he ought to have been saying, so...
I wasn't able to say that, but now that you said it, I adopt it. That... I think concludes on ground 3. So, in the next 15 minutes, I hope to deal with ground 4 and 5. Now, I was going to make a submission that my Lord put to my learned friend with which he agreed, which was that to some extent, some of the estoppel issues, at least as regards the Anderson claimants, are of little practical utility, because if abuse of process doesn't get home, then estoppel won't, and if abuse of process does, it's not needed. However, my learned friend was right to say that estoppel may have a significance in respect of other claims, whether it's future Anderson claimants' deductions or other employees' deductions, and that's where we get into this slightly surreal territory where this court is, in theory, determining grounds of appeal about what might be appropriate in a case that hasn't yet happened, or certainly hasn't yet been litigated.
Well, we don't necessarily have to do that, but we couldn't really just have left the Court of Appeal to stand, without the potential to review what they've said, because otherwise it'd just be accepted, wouldn't it, as not being challenged?
Well, up to a point, of course, as my learned friend rightly points out, there's very little on which even two of the three members of the Court of Appeal agreed in relation to estoppel. And so ground 5, the privity point, isn't dealt with at all by two of their Lord Justices. Ground 4, in relation to cause of action estoppel or issue estoppel, there is some community, but not by any means complete community between Lord Justice Underhill and Lord Justice Mayles. I'll deal with abuse of process then first, because it's that is something they all three agreed on, and certainly in relation to the Anderson claims, it's the most important aspect. I'm not going to take you, I'll give you the reference, you've all read it no doubt many times, the famous words within Johnson and Gore Wood by Lord Bingham at 1403, beginning between A and B. I'll simply...
Mr. Siegel, I'm going to have to ask you to keep your voice up.
Apologies. I was saying I wasn't proposing to take you to the full text of Lord Bingham's analysis of abuse of process. It's at 1403 within the Johnson and Gore Wood judgment. He refers to the need not to adopt too dogmatic an approach to the broad merits-based judgment, taking account of the public and private interests and all the facts of the case, focusing attention on the crucial question whether, in all circumstance, a party is misusing or abusing the processes of the court by seeking to raise before it the issue which it could have raised before. One example of the application of those principles is that failing to alert the court to the possibility of future litigation can give rise to abuse of process if that litigant then proceeds to such future litigation, which is what happened in this case.
But this is more simply a sort of Henderson and Henderson type case, that the claim, if it was a good argument, it was available and it should have been made when everybody was there to deal with it, and not have another go after you've lost the first one.
My Lord, indeed, and in fact, that passage of Lord Bingham that's so often cited is under a heading a page earlier, Henderson and Henderson. So it is an aspect of that more general principle. So I won't take you to that case or to the judgments of the Court of Appeal in this case, which focus on the need for a party to bring before the court its potential cases, even if in the alternative, even if, as was presumed in the Mango Hare case, that means that one set of proceedings is stayed for a period so that another can be concluded. And of course, that is not what happened in this case. We say this is, I hope I do not speak over rhetorically, a paradigm case, because unlike in the Alden case, or the Stewart case, which is also referred to, where a new claim entirely consistent with the original claim was pursued in subsequent litigation, and the only question was whether, as a matter of case management and the administration of justice, the claimant should have raised both at the outset. Here, Nexus is seeking two alternative bites at the same cherry. They've spent 4 years litigating whether the letter agreement means what it appears to mean, and it now attempts to set that entire litigation at naught, and having lost on liability, to argue at the remedy hearing the letter agreement doesn't reflect the intention of the parties, thus reversing the effect of the determination of liability. And the Court of Appeal, we say, was right to express robustly the view that that would be abusive. And in terms of the evidence that was relied on by the members of the Court of Appeal in relation to that, at 437, within a witness statement provided on behalf of Nexus, at the bottom of that page, Mr. Bartlett, the head of their Business Technology and Change Department, at paragraph 61, wrote, following the conclusion of the Court of Appeal in Anderson, senior counsel raised the possibility of a claimant pursuing a claim for rectification against the unions on the grounds of common or unilateral mistake. I think technically he should have written initially against the employees, but later against the union. And as Lord Justices Underhill and Mayles point out, the natural inference is that the line of defence simply hadn't been considered previously, and we therefore adopt their conclusion, Lord Justice Underhill.
Well, it doesn't matter which way round it is it? Either they hadn't thought about it or they had and decided not to make the point. So,
yes, I suppose.
either way round, they doesn't do them much good.
Yes. All right, well, I'll leave abuse. We say it is, again, not properly arguable. Estoppel raises more difficult and interesting...
Can you just explain why estoppel might ever be relevant? Does it depend on the privies point, or...?
No, the privies point assumes, just to be clear, that the appellant wins ground one, and then we are able to say, okay, so you've got across that particular jurisdictional threshold, but there's another one, which is that at least as regards the Anderson claimants, you're still estopped because the unions who you're now...
Okay, there's that argument, but what about if you win ground one, which is what the Court of Appeal
would deal with? Then the privies
goes,
and then, and I think I do agree with my learned friend on this, this is what I talked about, the slightly surreal territory. We're then imagining what claims might happen in the future. So they're in two categories, or three, I suppose. The Anderson claimants, having succeeded in their claim up to the point that they brought it, wish to bring claims for the same losses subsequently. That's category one. Category two, there are all these stayed claims by all the other employees along the same lines as Anderson. And category three, there's Nexus's right, which it has reserved, to do what it originally proposed to do if it loses ground one, which is to bring a rectification claim against employees, which would engage all of those issues that various members of the courts raised with my learned friend as to retrospectivity, etc., third-party rights. So it's in 1, 2, or 3 of those contexts that my learned friend, I'm sure rightly, foresees that an argument of estoppel might be raised. And it's certainly from those perspectives that the Court of Appeal expressly were directing their estoppel analysis. So as I said, as we said at the outset of our written case...
But given that the parties are different, except in the first case with the Anderson one, but for the stayed claims or for other claims, the parties will be different. So there can't be any issue estoppel, can there, or cause of action estoppel?
Not... Well... sorry, just 1 second. Can I just check? So we've got stayed claims.
Yes, so there are stayed claims.
Oh, right, sorry. The Anderson claimants themselves already have stayed claims in relation to subsequent deductions.
Right, so as regards them, it might matter. I can see that.
Yeah. Sorry, let me just get my head around the various ifs before we get to the... So we're assuming that the appellant loses on ground one and pursues its defence, which is already pleaded in, say, the Bolam case. Well, it certainly wouldn't give rise to a cause of action estoppel.
No. That can only work for stage 2 of the Anderson litigation, yes. Can't it?
I think that must be right, my lord, yes. Is that right? Can I just...
Yes, that's right.
Yeah.
So,
Right. Yes, well, I'm reminded that the privity of interest point has only been examined by Lord Justice Underhill in the specific context of privity as between unions and claimants, as opposed to privity between claimants and claimants. So there's nothing, as it were, even obiter for you to consider in that regard, or I suppose you're entitled to consider it anyway. I guess then my lord must be right in the context of what the Court of Appeal found and what Nexus is currently appealing. it is only in respect of the Anderson claimants' stayed claims where an issue of estoppel, we say, would arise. But we would ask you, not least because I haven't given the matter any particular thought, and therefore can't assist the court, we would ask you not to make any findings in relation to potential estoppels as regards...
I'm sorry, asking us not to
make any findings as regards potential estoppel arguments in relation to claims brought by other employees.
Well, I don't at the moment see how there could be any.
It's a concession I don't want to make, but I can't...
I mean, although you say in practice one tribunal is going to follow what the last one did, it's not because of any issue estoppel that requires it to. That's why you have representative actions and so forth, because every claim in principle is a different claim by somebody else.
My Lord, I can't think of anything sensible to say to controvert that proposition. So, without having instructions formally to concede it, the court will, if it feels appropriate, note that I was unable to controvert it. So that is right. The only issue then that does arise between the parties, and it is in relation to that narrow category, it seems to me worth exploring, is, in the last couple of minutes, is what is the scope of issue estoppel? Because there is an argument on the written cases, in particular in relation to the principle established in the Hoyster.
Forgive me, when you say in relation to that narrow category, which category are you referring to?
Anderson claimants' subsequent deductions.
Right. Thank you.
So what we say in our case is that if...
Sorry, that's the same as what you described as the stayed claims.
Yes, the stayed Anderson claims as opposed to the stayed claims of other employees.
Yep. Thank you.
We say that if an issue has formed a necessary ingredient of a cause of action where that issue has been admitted or assumed, it's my Lord's Henderson point, that is just as secure ground for an estoppel as if it has been controverted by the leading of that party. And in Hoysted, Lord Shaw, last citation of authority by me, I think, at 1347, on behalf of the board of the Privy Council, in the last paragraph of that page, have I given you the right? Sorry. I have a horrible feeling I've just written down the wrong page. No, I haven't. It is the right. I apologise. It is the last paragraph. So picking it up at the end of the first line of that last paragraph. In the opinion of their lordships, it is settled that the admission of a fact fundamental to the decision arrived at cannot be withdrawn and a fresh litigation started with a view of obtaining another judgment upon a different assumption. Secondly, the same principle applies not only to an erroneous admission of a fundamental fact, but to an erroneous assumption as to the legal quality of that fact. Parties are not permitted to begin fresh litigations because of new views they may entertain of the law of the case, or new versions which they present as to what should be a proper apprehension by the court of the legal result, either of the construction of the documents or the weight of certain circumstances, etc. Skip a couple of lines. The same principle, namely that of setting to rest rights of litigants, applies to the case where a point fundamental to the decision taken or assumed by the plaintiff and traversable by the defendant has not been traversed. In that case also, a defendant is bound by the judgment, although it may be true enough that subsequent light or ingenuity might suggest some traverse which had not been taken. That, we say, is this case, and therefore we respectfully adopt what Lord Justice Underhill said on the point, paragraph 78, page 206,
And is that distinct from the Henderson and Henderson jurisdiction?
No, on the contrary, the board makes clear that's an application of
Yes,
the Henderson and Henderson principles.
Right.
But I raise it because, unless I misunderstood, I'm not sure that on this one point we are ad idem, the parties, on the legal principles. I may be wrong, but out of an abundance of caution at least, that's our case. And as I say, at page 206, para 78, of Justice Underhill on the last 6 lines of that paragraph, the substance of the Employment Tribunal's finding in Anderson is that the sums in question are due. All the 96 Act does is to afford an alternative mechanism for vindicating the claim. The substance of the decision sought by Nexus as regards the pre-complaint deductions is that the self-same sums are not due. Thus, the ultimate claim is the same in both sets of proceedings. And we say that that grounds the estoppel in relation to the Anderson claims past and future. That issue was strictly conceded or at least assumed. And at paragraph 207, the next...
You say the issue was how should the pay be calculated? And it was decided it should be calculated whichever way it was, I can't remember now, and that's decided that issue once and for all. So as between those parties, that's how it must be calculated.
Yes, I put it slightly more in a slightly more pedantic way, I suppose. It was an issue that needed to be determined or assumed whether the written term was accurately recorded, and the parties contested the meaning of that term, to be sure, but did not contest the accuracy of its recording. They are not now, therefore, entitled to come back and say, well, we've argued for 4 years on the basis it was accurately recorded. We now want to argue a different point that it wasn't, because that had been assumed.
So that seems to me to be a sort of Henderson and Henderson, Johnson and Gore-Wood way of putting the point, rather than a more specific issue estoppel.
Yes, I mean, Johnson and Gore-Wood, the part I relied on at least, was entirely directed at abuse of process.
Well, that's why I, at any rate, was becoming a bit confused, because, I mean, as you pointed out, that passage in Johnson and Gore-Wood is addressing the operation of the principle in Henderson and Henderson, but the label given to it is abuse of process.
Yes, I take it that the analysis, and I haven't taken you to the leading authority of this court in the Zodiac Seats case, but the analysis of both abuse of process and estoppel draws on that same sort of from that same well, as it were, but there are more exacting criteria for estoppel.
But one thing maybe I've missed the point, but I thought you were focusing now on the stayed Anderson complaints, but you've taken us to the passage in Lord Justice Underhill's judgment that deals with the pre, because he doesn't find cause of action estoppel in relation to the post-complaint deductions. So I'm a bit confused. Sorry.
Just bear with me one moment, my lady.
It's 78 is what you just took us to, but at 92, he says the Anderson decision cannot give rise to a cause of action estoppel as regards the post-complaint deductions.
Is that just cause of action estoppel?
That's cause of action.
But yes. We're now on issue estoppel.
Issue estoppel, he does find, in the melee, as it were, I've lost the paragraph number, which I'm hoping my learned junior will just point to. Yes.
I thought he decides that the court wasn't in a position to deal with issue estoppel.
If you go to page 209, my lady, and I apologise for having to delay matters slightly, there's a heading.
Issue,
post-complaint deductions and issue estoppel.
Yes.
And it's the finding, as I understand it, this is the finding that ground for attacks in relation to estoppel. It's the findings at paragraphs 93 to 97 on which we rely and which my learned friend challenges. So it's as in the case of pre-complaint deductions.
But he says it's better for the court hearing the rectification claim to decide it. Doesn't he? That's his conclusion in 97. Not in a position to perform the necessary holistic exercise. And in the last sentence, better for it to be determined if it arises by the court hearing the rectification claim. And you haven't cross-appealed, or at least you haven't got an extant. Yes. So that's it, isn't it?
We're not have to close this down because otherwise, Mr. Reid.
Yes, you're right. I'm so sorry.
Yeah,
I'm afraid you're substantially out of time. Yes. Thank you, Mr. Siegel. Mr. Reid, you need to hear your reply.
Thank you. I'm going to take you to the contracts because you asked to see them and we've got them for you. Can I just pick up, there's obviously a little bit of language one has to be careful about with stay, because the Anderson claimants have got their remedies hearing stayed. They've also brought new claims which have also been stayed. And quite clearly, the distinction that was being identified there was between the previous claims on which there had been a liability finding, but no remedies hearing, and all the Court of Appeal were finding there were issue estoppels or abuse of the process about the findings that had been made on the existing Anderson claims. There was no permission on the cross appeal, so I acknowledge that this leaves open the arguments against me, but they are arguments which don't fall before the court as to any issues about either the Anderson claimants for deductions after the ones which were the subject of the proceedings, which were decided, or other claimants. I hope that helps. The contracts. We've emailed to the court. I've got hard copies if that helps immediately. I wonder if I could ask can we
I've already opened up your email.
Do you have the email?
Yeah.
Excellent, thank you very much. What you have is a standard format of contract for Nexus in relation to these particular employees, and you'll see that under the term collective agreement, it provides your terms and conditions of employment incorporate the collective agreements between Nexus and the recognised trade union for the negotiation of conditions of service for Metro staff, inverted commas, Red Book. And that's the general description. The actual statement of terms and conditions, which is a few pages on, also expressly includes that provision in terms of the agreements that are included. That's 2.3. So I start there because my learned friend really hasn't got an answer with respect to him for this fundamental problem, that if you say, are you rectifying the contract of employment, there's nothing on the contract of employment that's necessary or required to be rectified. What's self-evident on the contract of employment is what needs to be rectified is the Red Book. And the parties and the employees are not parties to the Red Book in terms of collective bargaining. That is the union and Nexus. Hypothetical scenarios about Nexus or no longer terminating collective agreements going forward and not having a union, or 2P assignments aside, don't change the fundamental position that the parties who are parties to that collective agreement in the Red Book are extant and the current collective agreement still governs the relationships. Therefore, we start from the proposition that the obvious answer to the question of rectification, if one's looking to rectify the Red Book, is that the appropriate parties would be the parties to that particular agreement. Now, my learned friend accuses me of revolutionary submissions in relation to the law of collective relations in the industrial sector. I only need to go this far, I say, in relation to this case, and this is where we are, which is that what we seek is not to enforce the collective agreement. That we recognise is prohibited by Section 179. We seek not its enforcement, but the rectification of a separate document which inaccurately records what the parties had collectively agreed. And I flip that round. My learned friend sort of decries any capacity for the unions to bring any form of claim. Well, I accept, of course, with my argument, that a union who found itself in dispute, that there was an issue between it and the employer as to what had been collectively bargained, because a document didn't record what they understood to be bargained, would itself be able to bring rectification in order to ensure that the document correctly reflected what had been bargained. No point of principle in either direction, I say.
And do you say that it applies to interpretation too? So that you could have a proceedings between the union and the employer about the meaning of the collective agreement because of its consequences for the employment contract?
I don't see an issue with that in terms of enforcement. I don't need to go that far, although I recognise the alignment between interpretation and rectification, because clearly it would be necessary to have some form of interpretation of what the parties have actually agreed in order to determine whether or not the document accurately reflected the common intention.
Yeah, I mean, I wonder whether when you get into interpretation of the document, you actually do need to bind in the employees, because they're the ones that you're saying should be bound by that interpretation, so that you would need to have proceedings against them to determine the meaning of whatever document falls to be construed. I mean, it just seems to me that there may be a difference between rectification proceedings, which are directed to trying to identify, well, what terms are we talking about, and issues in relation to the interpretation of those terms once you have identified what the terms are.
I see that point, and that distinction obviously has a reflection in the fact that my learned friend has made several times the point, well, the courts all the time look at the interpretation of collective agreements, and I don't take issue with that. He can identify many cases where that's occurred, and we all recognise that, but that's not the engagement one's exercise. The point of rectification is something rather distinct, and that's why it's necessary to identify it as being something which is specifically required to be focused upon what the agreement is between the parties, and the parties to that agreement being typically the necessary parties to the rectification action.
But what do you say to his argument that the courts don't entertain proceedings where there is no dispute between the parties to the proceedings about any matter of legal right or obligation as between them? Yes,
well, I think one has, in terms of that Whiteside and Raquel Group Services and Ashmore, has to be careful about those cases. I think virtually all the cases in the footnote to Chitty are all tax cases. And what happened in Whiteside, and one can see it when one comes, I'll take you to the passage where it's interpreted in Raquel Group Services, but the facts in Whiteside are just worth noting. What happened is that the husband, as part of a divorce settlement, agreed to pay the wife £1,000 net after tax. And the wording that had been put in the deed was at that time thought to enable the husband to seek tax relief on the payments. In fact, subsequent tax decision decided that the wording didn't have that effect, and he became liable for tax because he honoured his word so far as the intention with his wife was concerned, and that he paid her £1,000 without any deduction of tax. So she never had issue in a practical sense with the fact that she received what was intended to be received. And a critical fact which was clearly operative on the mind of the court in Whiteside about refusing to grant relief was that, because of course the wife was perfectly content with what had happened, she executed a deed, she agreed with him a deed that rectified the position going forward so that the correct tax position was achieved. So the only issue was that the husband was seeking rectification historically in order to seek repayment from the revenue of tax which he had paid in order to achieve what he intended to do for his wife. Hence that phrase that there was a fiscal advantage being gained from him. I say that what's clear there was that the issue wasn't a question of issue as to legal rights. It was really a recognition of the fact that there was no dispute at all between the husband and the wife. It was only about rectification being used as a means to obtain that particular fiscal advantage. And Whiteside it has not been without its criticism. If one looks at the passage that my learned friend took you to in the Raquel judgment, and we find that case at 1648. And in particular, he took you to the passage at 1157. I'm sorry. Sorry. Apologies.
No. 1654, I had.
You're quite right. 1654. If I just take you back to 1653, you'll see that this was another case where it was basically a tax case, and what had happened again in relation to this is that there was tax relief. The company was entitled to tax relief if it made payments by way of a deed to a charity which lasted more than 3 years. And due to an error in the dating of the documents, they fell short of 3 years by 3 months. But there'd been no amendment of the deed. It stood without amendment. So there was formally still an issue between the parties in the sense that the document still reflected something which hadn't been the common intention of the parties. But the court looked at Whiteside below, and the passage that my learned friend took you to, which summarised the judge below's judgment in relation to matters, reflected the fact that the court below found Whiteside difficult to determine as to its key principles, and it had been criticised in subsequent cases, not criticised, but the court in subsequent decisions have found it hard, also tax cases, to interpret what the principle was in Whiteside. Now, I acknowledge that the summary that the Court of Appeal approves on page 1654 refers to the fact in the last sentence that the court may decline to grant relief between the parties between grantor or grantee and intended beneficiaries. The rights will be unaffected if the effect of the order will be to secure a fiscal benefit. I don't read that with respect to suggesting that the question is whether or not there has to be some extant dispute as to legal rights. In fact, in the context, it was really only referring to the fact that this was parties who were not in dispute, had no issue between them, whether legal or otherwise, but were seeking rectification to gain a specific fiscal benefit from the tax authority.
But the parallel here is that you're bringing this claim against the union to secure a collateral benefit by as against somebody else. As between you and the union, there's nothing. It doesn't matter. But as far as they're concerned, what the answer to this question is.
I know, but there is an issue between us and that's the practical effect. They say, because they're here arguing this position, that they don't accept that the letter of agreement does not accurately record what was reached by way of collective bargaining.
But the question then is, do the courts entertain that dispute for the benefit of litigation with somebody else, when as between the two parties, no legal consequence can turn on it?
Well, there is a legal consequence, and that consequence is going forward, because the point my learned friend again can't really deal with is that if there's a determination, say in the employment tribunal, if rectification is there, he accepts that there is no power of rectification there, it's just a decision between the employer and the employees. But what's my position if I've got an uncooperative union for new employees? When I hand them their new contract of employment that says the terms are in the Red Book, the union continue to say, well, the terms are in the Red Book as we say they are what they mean, because they've not been subject to an order for rectification. They're not parties to the employment tribunal litigation. They're not parties to the litigation in relation to the employees. If they wanted to be difficult, and I'm not saying this of these unions, but it's capable, they could be saying, we don't accept or recognise this decision as binding upon us about rectification because we've not been subject to an order for rectification. The collective agreement has not, the letter of agreement has not been rectified. And when you offer different terms to workers, because you say it's been decided by an employment tribunal between individual employees that it means something else, you're departing from collective bargaining, and it's an inducement to depart from collective bargaining. But the problem is that if there is no power of rectification, and it's accepted there isn't in the tribunal, and there will be no power effectively between the employees to rectify that separate agreement, on my learned friend's argument, the really only place for the power of rectification is as against the union, because that's where the agreement rests. So I say it's not an answer to say the fact that it's not an enforceable contract doesn't change the practicality and the effect of the issue, or therefore require a point of principle to arise to say that the court will not grant rectification. Can I just in 1 minute deal with one point, which is that my learned friend relied on Hasted. In Hoisted, it's worth noting in Hoisted that there was an express concession in that particular case. It's another tax case, and it involved tax assessments in 1 year, and then a decision whether or not in subsequent years the concession which had been made as to the taxable position in earlier years bound the position so far as the revenue was concerned. But it was an express concession. You can see that at page 1346 of the judgment. It's right then to say that that case was subsequently questioned in a case called CAFOR and the Commissioner of Income Tax, because what wasn't... The name of the case? I'm sorry, CAFOR, C-A-F-F-O-O-R, and that's at page 1029. And in CAFOR, what was pointed out that the court in Hoisted had not had brought to its attention that there was a decision that each tax year's assessment was a separate assessment in itself, and no previous concession bound the revenue as to a different year's assessment. So it can properly be regarded as being a decision per incurium. We don't regard it as taking it any further than the existing principles. I've strayed beyond my time. I do apologise.
We're grateful to you, Mr. Reid, and to Mr. Siegel, and to your juniors.
Yeah, we should decide afterwards whether we want to do it or not. Yes. Yeah.
Mr. Reid, Mr. Siegel, we're very grateful to you, to your juniors, for your assistance, and also to those behind you for the preparation of the case. We'll take some time to consider this matter. Court is now adjourned. Thank you very much.
My Lord, if I may say, I think for the interest of open justice, I should make it clear that I take it that dinner's off, Lord Burrows. And that...
Only if you write that down.
I don't know. I think we can make the declaration, can't we, that you're buying the wine.
Thank you all very much.